Yes.
If we please your lordship, my lord, I beg to mention item number 24 of today's cross list, my lord. My lord, the Arving advocate, he is from Shillong, my lord. He could not come today. So the matter may be taken up after 2 weeks, my lord.
Twenty-six.
20,
26.
24, 20.
You have informed the other side.
I'm from promotional side.
This is enough.
Yes, Your Honor. I'm from the April. Other side.
Heard Miss, what is her name? Heard Miss M. Kurmilan at counsel for the appellant. Also heard Miss
Sobita Mohan.
S. Mahanto, learned counsel for respondent number 1 and 2. Learned counsel for the appellant seeks an adjournment as the conducting counsel for the appellant is an outstation counsel and has some personal difficulty today. The prayer is not opposed to by the respondent's counsel, hence same is allowed. Let this matter be listed after 2 weeks on a date to be fixed by registry.
May I please, Your Honor? I have not received the copy of IA.
Furnish the copy of the IA. The appellant shall furnish the copy of the interlocutory application to the learned counsel for the respondent within a week from the date of this order.
My lord, this is an MSc appeal, my lord. It was lastly listed on May 2022. My lord, may I pray for listing this matter on next week, my lord?
What is the, who in which column?
My lord, orders column.
Okay, next week on a date to be fixed by registry.
Also, with due consent from the other side, I beg to mention item number 15 to 18, Lordship. In 15 and 17, I am for the petitioner. And in 16 and 18, the state is the petitioner. So I pay for adjournment today, Lordship, on fixed on Friday, if possible, Lordship.
Orders column. Heard Mr. S. Deka, learned counsel in item number 15 to 18. Learned counsel for the review petitioner in
Item number 15 and 17.
item number 15 and 16. यहाँ से देख ले. Also heard Mr.
J. Singh, my lord.
J. Singh appearing for learned
Respondent 1 and 3.
learned government advocate appearing for respondent number 1 and 3. A prayer for short adjournment has been made by learned counsel for the petitioner, which is not opposed to by the government counsel. Hence, same is allowed. Let this matter be listed when?
15, Lordship.
On 15th of May.
Published.
May I please, Your Lordship? I paid for listing an MSc appeal in orders column, Your Lordship. I am for the claimant.
Next week on a date to be fixed by registry.
Your Lordship, I am paying for listing on MSc appeal. Matter is already settled in mediation.
When do you want?
Tomorrow, Lordship.
Okay, tomorrow.
Lordship, I beg to mention item number 5 for withdrawal.
What happened?
As per client's instruction, a compromise has taken place.
Miss
People.
P. Bora, learned counsel for the appellant, who submits that she has been instructed by the appellant to withdraw this matrimonial appeal, as the matter has already been amicably settled between the parties. Stop considering the submissions made by learned counsel. The prayer is allowed. This appeal is dismissed on withdrawal.
His Lordship. Lord, I beg for listing of MSc appeal in orders column on 13th.
No fixed date. Tomorrow. No fixed date. Registry to list it in the next week on a date to be fixed by it.
May I please, Your Lordship? Lordship, I am going to mention for listing 2 MSc appeal. One is for hearing and another is for work.
Hearing, no mentioning. You pray before the registry.
For orders immediate lordship.
Orders next week on a date to be fixed by registry.
May I please, your lordship, I beg to mention a matter CRP in for listing in admission column in this week.
CRP. Court number 3.
Your lordship, may I plead for admission, a listing of MSc Appeal 98 of 2021.
Next week on a date to be fixed by registry.
Much obliged.
May it please your lordship. Lordship, on Friday, the hearing took place. We were supposed to give the judgment, lordship. I'm handing over. The insurance, in the appeal filed by insurance company, enhancement cannot be done on that point. And your lordship.
You write the make appeal. Okay. Okay.
Item number 1.
But am I audible to your lordship?
Item number 1. Yes.
May it please your lordship. Lordship, I am appealing for opposite party number 1, lordship.
Yes, Mr. Dubey.
I'm sorry. Station, but I have an item 36 minutes. But this is a land acquisition appeal and there is a delay, Milord. Only notice has to go. But I'll try to be present, Milord. Otherwise, I'm before a tribunal in Delhi. So if my colleague
Item
would be
number?
there, Milord, in item number 36 minutes. 36 minutes.
Have you informed the other side?
No, Milord, there is no other side, Milord, because notice has to go. Milord, this is an appeal by Airport Authority of India. There is a private party and
Heard,
the state
Mr.
is, Milord,
Heard,
just a
okay.
proforma.
What is your prayer?
Not notice to, because there is a delay a few days, Milord, in filing that appeal, Milord. That's it.
No. What is your prayer?
Milord, my prayer is, Milord, I'll try to be present, Milord, when the matter will be called. Milord, I'm just making, in case my colleague may be allowed to, Milord, represent, Milord. That's it, Milord.
No, you are not audible what you are speaking. What is your prayer?
My prayer is, Milord, that only notice has to issued in that case, Milord, because there is a delay condonation, Milord. I may stuck up in the matter here, Milord. That's why, Milord, I'm.
Okay, no, then why you are mentioning we'll take up the matter in seriatim when the matter comes up for.
Your lordship
We'll
would take
issue
it in
notice,
secret,
we'll
Milord,
show
in
your
case I
presence.
don't appear, Milord.
We'll show your
Yes,
presence.
Milord. I'm
Okay.
deeply obliged.
Okay, yes, one.
Sure.
In this case, lordship, I am appealing for opposite party number 1. I have not received a memo of appeal, lordship.
I'll furnish, my lord. For enhancement, my lord.
Whether notice has been issued to. How many respondents are there?
On the sole respondent, my lord.
Record ISNA.
TCR, my lord, already received, my lord.
I responded as well.
Heard Mr. S. Ahmed, learned counsel for the appellant. Also heard Ms. M. Chaudhary, appearing for the
Since company lordship, number two, so respond.
Sole respondent.
why you have not made other opposite parties.
The award has been passed, my lord, only against the, my lord, respondent number 1, my lord, the sole respondent.
Appearing for the sole respondent, who submits that she has not yet received the copy of memo of appeal. the appellant is directed to furnish copy of memo of appeal along with annexures to the learned counsel for the sole respondents. It also appears that the records of MSc case number 1469/2015 has already arrived, and hence this matter is ready for hearing. List this matter for hearing.
Admission.
It is already admitted.
Yes.
Final hearing in the month of August on a date to be fixed by registry.
If possible, my lord,
Must apply, sir.
otherwise long pending matter.
Ramesh Atam,
If
Augusta.
possible, my lord.
7th of August.
My lord, obliged.
Must apply, Lordship.
Item number 3. Please.
Item number 2, মাতকচোন কোনোবা আছে নি? 2 কল কৰকচোন।
Item number 2.
No, what has happened in this case? Why?
Father, the custody of the child.
Oh, it is a custody matter.
Yes, Lordship, personal appearance.
Okay, okay,
At
we'll
150.
150.
He has come.
Okay, we'll take it up at 150.
It will be in camera and sitting
Okay.
office.
Item 3. Hello, before pending of document. If you take a reason like code 6.
Okay, we'll take it up after Sunday. After Sunday.
My lord, the matter is, we have not received the memo of the appeal, my lord. Let the copy be served.
You, sir. Then we'll fix another date. Heard Mr. A. Deka, learned counsel for the appellant. Also heard Mr.
Yes, sir.
S. Sharma, appearing for the respondent, who submits that he has not yet received the copy of memo of appeal. The learned counsel for the appellant is requested to furnish the copy of memo of appeal along with annexures to the learned counsel for the respondent during the course of the day.
Another prayer, my lord. My name may be reflected, my lord.
Name of Mr. S. Sharma be reflected in the cause list as engaged counsel for the sole respondent henceforth.
Why not be done 2 days time to give the copy?
Copy during the course of the day, Jagat Likhok, within 2 days from the date of this order. Let this matter be listed again on June. 10th of June.
Madam.
Item number 4.
Heard Mr. D. Shah. What is this?
My lord. Appeal against order dated, my lord, 12/2/2020 in a case of succession.
It was allowed or rejected?
Yes, allowed, my lord, but my lord, the honorable court below did not consider the no objection petition, my lord, filed by respondent. That is why I am appearing here, my lord. On the other hand, my lord, in the impugn order, my lord, the succession certificate was issued against all my lord, respondent. Next of kin, that is next of kin. But the petitioner filed by petitioner, and against that, the respondent, the present respondent filed no objection petition, my lord. Loknath Rajbangshi.
Who are you? Patiram Rajbangshi. And who is Loknath Rajbangshi?
Father of Patiram Rajbangshi, my lord, and the deceased, against which debts and liabilities the petition was filed for your honor. Both are, all are brothers, your honor. There is no any dispute, my lord, regarding the issuance of succession certificate in favor of petitioner, my lord. My lord, on the 28/7/2025, the present respondent filed no objection petition, my lord, stating entirely that
Okay,
is no-
let the respondent appear. Heard, Mr. What is your name?
Ishona.
D. Sharma, learned counsel for the appellant. This appeal under section 384 of Indian Succession Act, read with Order 41, Rule 1 of the Code of Civil Procedure, has been preferred against the judgment and order dated 12/2/2026, passed by the Court of London, District Judge Dharam, Mongolde, in Miss within bracket SC case number 6/2025. Stop. I have gone through the grounds stated in the memo of appeal. The appeal is admitted. Issue notice to the respondent and call for the records of Miss SC case number 6/2025 from the trial court. Registry to take steps for requisitioning the records. The appellant shall take steps for issuance of notice upon the sole respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 12th of June.
Item number 6.
Chip, kindly pass the matter for the time being. My senior counsel is on legs.
What is the case, Mr. Gosa?
It's a MFA case, Lordship, arising out of a WC case. Lordship, in this case, the workman claims to be the driver, but there is not a single GD entry, not a single FIR, not even the license DL was produced before the commission. These are jurisdictional facts. This ought to have been proved with evidence. That is one GD entry.
What is the substantial question of law which you have proposed?
In page, Lordship. 8. Quoted in the given facts, when the claimant did not prove the original facts like the injury arising out of in course of employment, does the learned commissioner have the jurisdiction to make the insurer liable for compensation? Again, there are two questions, Lordship.
Okay, who will be coming?
M. Doctor.
Let him come. We'll take it up after some time.
Supplementary item 49.
This is a regular first appeal, Lordship.
Supplementary list code. Yes.
In this case, what happened, Lordship? The present appellant earlier defendant in a title suit, Lordship, filed by his own sister, Lordship. That title suit was decreed in favor of Rabia Bibi, then Lordship Rabia Khatun Bibi, and then he preferred a title appeals. Then First Appellate Court reversed that judgment. That annexure 1, page 13, Lordship. They were both brother and sister, relevant prayer of
Who is the appellant here?
Kasem Ali.
Okay.
Srimati Rabia Khatun Bibi, Your Lordship, you find in page 13. She is the sister of Sri Kasem Ali, who filed the suit was decreed, then title appeal was preferred by Kasem Ali. That
Yeah.
judgment I have annexed. Page 15, your lordship will find the prayer portion from the first paragraph, last lines. The plaintiff thereafter called for village salis, but the dispute could not be amicably settled. Hence, this suit praying for the declaration of the right, title, and interest of the plaintiff over the suit land and for eviction of the defendant from the suit land. So the suit of the respondent was lordship for right, title, interest and eviction. That means Kasem Ali was in possession. But after the judgment of this first appellate court, she preferred regular second appeal, and that is pending before this Honorable High Court.
It is RSA.
That is lordship RSA 355 of 2017.
And the present appeal is against we.
Present appeal is against lordship during the pendency of regular second appeal. The legal heirs of Rabia, she died, lordship. Legal heirs of Rabia disposes this present appeal. So he filed a second suit. That is lordship, your lordship will find the order dated copy of order dated 13/5/2024 in IS. No, lordship, impugn order is 22/3/2024, page 56. By that order, my plaint was rejected, lordship. That is page 56, annexure 7. But in fact, cause of action for both the suits are different.
Against
This present regular second appeal. Parties are duly represented. Peruse the case record. It appears that today the case was posted for hearing in respect of petition number 595 of 23 and 1683 of 24 regarding the stay of the instant suit. Heard the learned counsels of both sides, made a shift of grounds set forth in the aforesaid petitions. No objection is filed by the other side in respect to the aforesaid petitions. Peruse the pleadings of the parties along with the documents appended therewith. Upon perusal of the aforesaid documents and after hearing of the parties, it appears that the subject matter issue and the parties of the instant suit are similar to the title suit number 337 of 2010, which was disposed of between the same parties and presently sub judice before the Honorable Gauhati High Court in RSA 355 of 2017. So in view of that matter, I am of the considered opinion that the instant suit is not maintainable, being barred by the principle of res judicata. However, the parties are at liberty to approach the Honorable High Court in connection with RSA 355 of 2017 for reporting any subsequent developments that had took place or
in
might.
this suit you prayed for recovery of possession. And what else?
Recovery of possession, lordship, that is plain page 30. But that suit was filed by Rabia lordship claiming right title interest and recovery. Now we are praying for right title interest of page 36.
Yes.
A decree declaring the right title interest of the plaintiff in the suit land described in Schedule B, a decree for correction of record of rights of the suit land in the name of the plaintiff and for issuing Kiraz Miadi Patta in his name.
These two prayers were there in the earlier suit also.
That was filed by her, Rabia. Kasem Ali was defended. Only
What happened to her suit?
her suit is lordship regular second appeal is pending.
Her title suit number was?
Decreed, lordship. That was
What is the number?
That is lordship 337 2010 by Munsif number 1 Dhubri in title suit, lordship. Munsif decreed the suit, then Kasem Ali preferred the title appeal. And first appellate court reversed, lordship.
First appeal, title appeal case number?
Lordship 67 of 2013.
Against that reversal, she approached this court,
This
and that is still pending.
Lordship, when the regular second appeal was filed, they did not meet Kasem Ali as party. So we approached the Honorable High Court for implement of Kasem Ali in the regular second appeal. But Honorable High Court said that when they did not made you party, it's not required to implead yourself. So thereafter, we have withdrawn that petition, Lordship. So during the pendency of the regular second appeal, Rabia died. Her legal heirs disposes the plaintiff from the suit lien. So the right title interest and recovery of possession was claimed by Kasem Ali by the subsequent.
But your right title and interest was
They have
declared in title appeal 67.
that there was no counterclaim. Already the right title interest in favor of Rabia was negated by the first appellate court. There was no counterclaim by the defendant.
So whether res judicata applies?
My opinion, Lordship, res judicata will not be applicable.
Yes,
As
Mr.
because subsequent cause of action.
Perhaps, my lord, this order is not that correct, my lord. The order passed by learned court below. Because, my lord, the issue of res judicata cannot be determined like this. An issue has to be framed, my lord. That
Yeah.
will have to be examined.
Yes.
And this, my lord, arose from a petition which was preferred by them under section 10, praying for only stay.
Stay.
But that was converted to a question of res judicata without even framing any preliminary issue.
And res judicata, because matter is still pending before,
Decided.
it is not finally decided.
Yes. So-
How is it?
Yes.
The cause of action.
It is a case of stay of suit.
Yes, so my humble submission is this, matter. Let the matter be remanded back with a direction to the lower court below to decide the matter afresh, their petition, which
Our
was
petition was under section 10.
section 10, which was converted to section 11 petition.
Who converted?
Lower court below,
Court.
because there was no such prayer under section 11. Neither we filed any prayer.
Okay.
Our petition is annexure 4, Lordship, page 47.
Page 47.
51, man. Page number 51. 1683.
What is this 51?
The petition, manner filed by the plaintiff.
Two petitions filed, Lordship. Earlier petition is page 49.
That was withdrawn.
That
That-
was
that was
first withdrawn, Lordship. Then this page 51 petition was filed, Lordship.
What is the prayer?
At page number 53, madam. Not to proceed with the suit, and the suit be kept in abeyance till disposal of the RS.
So it is an application under section 10.
Yeah.
Why you withdrew the earlier application?
Lordship, that was withdrawn that. In fact, Lordship, this petition is also not maintainable. That suit can be proceeded in accordance with law. But the plaintiff filed this suit, this petition, Lordship. Page 49, annexure 5 petition is that the plaintiff had filed the suit for declarations, correction of record, and for permanent injunction before the honorable court, and the suit is pending for its disposal. That the plaintiff have fixed the suit and filed a petition right number 595 dated 17/3/2023 as per section 10 CPC to stay the proceeding of the suit till disposal of the RSA number so and so, and the plaintiff withdraw the petition and not press the same. It is prayed that the honorable court be pleased enough to pass necessary order as deemed fit and proper for the answer.
This application you filed for
16
withdrawing,
Yes, Lordship, 16.
for withdrawing the petition which you filed at page 47.
Yes, Lordship. No, this is, Lordship, it is prayed that will be pleased enough to pass necessary order as deemed fit and proper for the ends of justice. Earlier petition, that is, Lordship, 47, annexure 4, petition under 10 of the CPC. Then page 51 petition was filed that the plaintiff has filed this suit for declaration of right title, eviction, correction of record, and for permanent injunction before the honorable court, and the defendants appeared and submitted their respective written statement that it came at the knowledge of the plaintiff that the predecessor in interest of the defendant numbers 1 to 4 filed a case RSS so before the Honorable Gauhati High Court against the title appeal number so of the Honorable Court. That in the original title suit number so the present plaintiff contested the suit as defendant and the suit was decreed in favor of the predecessor in interest of the present defendant numbers 1 to 4, that is Rabia Khatun Bibi. That in the title suit so the present plaintiff failed to submit the counterclaim in relation to the suit led for claiming right title and thereon. That after filing the case number so the present defendant numbers 1 to 4 disposes the plaintiff. So during pendency of the RSA, they dispossessed from the suit lien and the plaintiff filed the present suit with the release for declaration of right title interest and from eviction from the suit lien with new cause of action.
In this appeal, Mr. Das, you are appearing for?
For my lord, respondent number 1 to 4.
State.
Earlier, in earlier occasions, they appeared.
And okay. Heard Miss R. Chaudhary, learned senior counsel assisted by A.C. Murtaja, learned counsel for the appellant. Also heard Mr. S. Das, learned counsel for the respondent number 1, 2, 3, and 4.
I'm also appearing for 7 to 11 and 13 also.
1, 2, 3, 4, 7, 8, 9, 10, 11, and 13. None has appeared for respondent number 5 and 6, though they were ripped.
Name shown, Lordship, MS M.
Though on earlier occasion, learned government counsel Miss M. Kalita had appeared for respondent number 5 and 6. It also appears that since respondent number 12 had expired by order dated 30/3/2026, this court directed to strike out the name of respondent number 12 from the memo of appeal. In this appeal under Section 96 read with Order 41, Rule 1 of the Code of Civil Procedure 1908 has been preferred by the appellant Qasim Ali, impugning the order dated 22/3/2024 passed by the Court of Learned Civil Justice Senior Division Dhubri in title suit number 26/2022, whereby the suit filed by the present appellant was dismissed on the ground that same is barred by the principles of res judicata. The brief. Where is your plaint in this suit?
30, Lordship, prayer portion. That is page 36.
The next paragraph. The brief facts relevant for consideration of the instant appeal, no, not relevant for consideration of instant appeal, are that the present appellant filed a title suit for declaration of his right title and interest over Schedule B of the over land described in Schedule B of the plaint, along with the said relief, the relief of recovery of khas possession by evicting the defendant number 1 to 4 was also made in the plaint. Learned counsel for the no senior counsel for the appellant submits that the predecessor in interest of the present respondents, namely Miss Rabia Khatun is no more,
Yes, she died.
namely late Rabia Khatun Bibi had filed a title suit before the court of Munsif number 1 Dhubri, seeking declaration of her right title and interest. In respect of the title suit 337, plaint is not there.
Title appeal judgment, I have a name.
What was the suit length?
Page 15, your lordship will find. Schedule A land amicably and accordingly the plot of land measuring about 7 bighas, 8 places. Schedule B land fell in the share of the plaintiff. So recovery of suit land of Schedule B, lordship. The plaintiff principal respondent had alleged that the principal defendant appellant does not have any right, title, or interest.
In respect of suit length, the said suit was registered as title suit number 337 of 2010. The trial court decreed the said suit against the present appellant. Stop. She further submits that being aggrieved by the decision of the trial court, the present appellant preferred an appeal before which court?
Your lordship, senior division.
Before the court of learned civil judge Dhubri.
Civil judge Dhubri, lordship, on the page
Dhubri.
13.
The said appeal was registered as title appeal number 67/2013. In the aforesaid appeal, by judgment dated 9/2/2017, the first appellate court allowed the appeal and reversed the judgment of the trial court and dismissed the suit of the original plaintiff. Stop. She further submits that on being aggrieved by the decision of the first appellate court, the predecessor in interest of the present respondents, namely late Rabia Khatun Bibi, preferred a approached this court by filing a regular second appeal.
Page 58.
The said appeal was registered as RSA number 355, page number
58.
355 slash 2017, and the said appeal is still pending before this court.
The present appellant was not made party.
Learned senior counsel for the petition appellant further submits that why the appeal, it is on your
Yes, Lordship, on my appeal,
the decree was reversed. Then
Lordship will find in page 13 for a moment.
how without you the RSA is maintainable?
There is Sri Kashem Ali versus number 1 Sri Rabia Khatun Bibi, then 1 the state of Assam. Maybe at the time of preparation of the regular second appeal, they have filed the regular second appeal on the pretext that Rabia Khatun Bibi against the state of Assam circle officer. So accordingly, the names were written as Rabia Khatun Bibi, page 58, versus the state of Assam and 7 others.
You were not made party.
No, Lordship.
Then how second appeal is maintainable?
For that, I have filed one IA Civil 638/2024, page 60. But that was later on withdrawn. Lordship.
She further submits that in the said appeal, the present appellant was not made a party. She further submits that though an application for impleadment of the present appellant was filed in the aforesaid regular second appeal, however, later on same was withdrawn.
Not regular second appeal, page 60, by IA Civil 638/2024.
No, this IA is in connection with the regular second appeal.
They are regular second appeal.
Yes. Read this last line. Though an interlocutory application was filed in the aforesaid regular second appeal for impleadment of the present appellant
IA Civil
as a party in the aforesaid regular second appeal. However, the interlocutory application was later on withdrawn. She also submits that during the pendency of the aforementioned regular second appeal, the present appellant was dispossessed by the legal heirs. Who dispossessed him?
The legal heirs of
By the legal heirs of late Rabia Khatun Bibi from Schedule B land.
That is the same plot of land involved in the earlier suit. Lordship.
As such, the present appellant had filed the title suit number 26/2022. She also submits that in the earlier suit filed by Rabia Khatun Bibi, no counterclaim was filed by the present appellant.
Because at that relief point of time, there was no cause of action. We were in possession.
As at that point of time, the present appellant was in possession over the plot of land which is involved in the earlier suit, and presently within bracket, presently RSA number 355/2017.
Page 35, paragraph 10.
Stop. Learned senior counsel for the appellant further submits that since the regular second appeal number 355/2017 is still pending before this court, and since the suit land in respect of title suit number 26/2022 is the same land as involved in regular second appeal number 355/2017, the present appellant had filed an application before the trial court. In your own suit, you filed an application before the trial court under section 10 of the Code of Civil Procedure, praying for staying the title for staying this title suit number
26/2022.
26/2022. However, the trial court instead of staying the suit, on its own motion, instead of staying the suit, dismiss the suit filed by the present appellant, holding the same to be barred by res judicata, stop. She submits that in the title suit, whether a other defendant appeared, you appeared
Yes.
in 26.
Yes.
You filed WS.
That is annexure 3, Lord.
Yes.
Any issue regarding res judicata was framed?
No, no. Whether any issues were framed out or whether that will be apparent only from the orders itself.
But in the orders, there is no reflection.
The court itself converted those two petitions into a petition to be considered as a suit is barred by res judicata.
Stop.
She further submits that
In fact, no objection.
even though the defendants did not objected to the petitions filed by the present appellant for staying the suit, the trial court on its own motion, without framing any specific issue in that regard, and without calling for the records of title suit number 337/2010, disposed of the suit filed by the present appellant within bracket title suit number 26/2022, holding the same to be barred by res judicata, which she submits is an irregularity committed by the trial court. She further submits that since the regular second appeal number 355/2017 is still pending. The final decision in suit filed by the predecessor in interest of the present respondent, that is title suit number 337/2010, is
Subject.
yet to come. And hence she submits that it is a fit case for applying the provisions of section 10 of the CPC.
What happened, the annexure 4 piece, petition under section 10 was withdrawn by a second petition. Thereafter, they filed the 1683 petition for praying for to kept in abeyance the suit.
That is the meaning. That is what is provided in section 10.
Lordship.
Keeping in abeyance and stay of suit are same thing.
Same, but Lordship, they have filed a petition under section 10. Then they withdrawn that petition by the annexure 5. Then annexure 6 petition was filed where prayer is to kept in abeyance, Lordship.
So she further submits that though the petition number
595.
no petition number 801/2023 filed by the present appellant under section 10 of CPC was later on withdrawn by the present appellant. However, it again filed an petition within bracket petition number 1683,
81, Lordship. Page 50.
page 51.
Page 50, your Lordship will find left side 1681/24.
And what is 16, page 53?
1683, Lordship will find the suit rights. That is, should be kept in abeyance till this.
Yes. And here petition number 1683/2024 for keeping the title suit number 26/2022 in abeyance. However, the court, instead of the trial court, instead of deciding the said application for keeping the suit in abeyance, dismissed the suit on the ground of res judicata. She submits that this is a fit case where the matter may be remanded back to the trial court to reconsider the application filed by, reconsider the petition number 1683/2024 filed by the present appellant, praying for keeping the title suit number 26/2022 in abeyance during the pendency of the regular second appeal number 355/2017.
In accordance with law.
Yes, stop.
As people, Lordship, that petition, Lordship, I will advise to withdraw that petition. As because both the cause of actions are different, that's why it will proceed, Lordship. That was a file, the wrong advice, in fact, Lordship.
No, but now we will remand back.
Yes, Lordship. Reconsider the petition as per law, Lordship.
Yes.
The liberty, my lord, to the other side to file objection, my lord, because written objection was not filed by you.
Stop. On the other hand, learned Mr. S. Das, learned counsel for respondent number mentioned Koribu Agojiase, fairly submits that the trial court appears to have erred in dismissing the title suit number 26/2022 by holding that same is barred by res judicata, whereas the regular second appeal number 355 is still pending before the High Court.
Observations are also different.
Stop. I have considered the submissions made by learned counsel for both sides. Though learned counsel for learned senior counsel for the appellant has submitted that in the suit filed by the present appellant, the relief sought for, the cause of action and the relief sought for were different, as the present appellant, who was in possession of the scheduled bill and was dispossessed therefrom during the pendency of the regular second appeal number 355/2017. Stop. It appears that since it appears prima facie that since the regular second appeal 355/2017 is still pending, hence the final outcome of the suit filed by the predecessor in interest of the present respondent within bracket TS 337/2010 is yet awaited, and hence it appears that the provision of section 11 of the Code of Civil Procedure may not be applicable at this stage. The trial court appeared to have erred on this count while passing the impugned order. Accordingly, this is a fit case for remand of the case back to the trial court. Stop. The case is again remanded back to the trial court with a direction to reconsider the application 1683/2024 filed by the present appellant, which apparently is an application under section 10 of the Code of Civil Procedure 1908, though specific mention about that is not there in the said application. Stop. The trial court shall also afford an opportunity to the present respondents, number so and so, to file a written objection, and thereafter, after giving opportunity to both the sides, shall decide the said application and proceed with the suit accordingly.
Petition was filed on 3/1 in the month of January, and thereafter the order was passed in the month of March. No written objection was filed earlier. So may I pray, Lordship, that may not be recorded, as they have already lost that opportunity.
That will be apparent only if the records are there before this court. So,
Yes, Lord.
since this matter is remanded back, so an opportunity may be given, man.
16, 18.
Even if, because your stand now is that you have wrongly filed that, so let them file objection. This appeal is accordingly disposed of.
Any date fixed, Lordship?
Oh yes, the before disposed of applicable, the title suit number 26/2022 is restored to file shall be restored to file. And since both the parties are represented before this court by their engaged counsel, both the parties hereto are directed to appear before the trial court in title suit number 26/2022 on suggested date.
April,
1st of June, man. First or
first of
second.
June, first of June, Monday.
1st of June.
Yes.
On 1st of June. Let a copy of this order be sent by the registry to the trial court immediately.
Deeply applies.
Highly applied.
Item number 50.
Alage.
Yes.
Dispose of.
These are
Yes.
My lord, in this matter has been transferred from the Bongaigaon District Court. My lord, title appeal has been transferred to the High Court. My lord, 6 weeks time may be granted to reconstruct the file now.
No, I'm not getting you.
My lord,
What happened?
My lord, this title appeal was transferred due to the change of the pecuniary jurisdiction, to the High Court. And subsequently, the matter was not listed because the documents were not available with the parties and with the registry also. Subsequently, the High Court file has also been reconstructed. 6 weeks time may be granted so that we can also reconstruct the file. We apply for website copies.
You're for?
The Transport Department, 2 and 4, ma'am.
Who is the appellant here?
My lord, the state, my lord. State of Assam, my lord. Page.
Yes. Mr. What is your name?
R.B. Goswami.
R.B.
Goswami.
R.B. Goswami. Learned Standing Counsel.
Transport Department.
Learned Standing Counsel, Transport Department. Who submits that what happened to original file?
Well, the original files we do not have, my lord, records. And
Who prays for 6 weeks time to reconstruct the No, you don't have your own brief that who submits that the
we apply for certified copy.
the appellant's learned counsel for appellant, the brief of the present appeal is not traceable and therefore says he seeks 6 weeks time to either trace it or reconstruct the necessary paper. The prayer is allowed. Let this appeal be listed again after 6 weeks on a date to be fixed by registry.
Otherwise, the title appeal was stayed in the trial court, my lord. That record is also there in the IA.
Which
My lord,
Ramesh.
I think it should be in my lord 753.
783.
753, my lord. There's 753 and 84, my lord.
753 I said.
Well,
No.
it should be 783, my lord. 7.
What is the prayer?
My lord, it was stayed in the trial court, my lord, by order dated 23/2021.
So what do you want?
The stay may continue, my lord.
Stay is already granted by the trial court.
My lord, it is already.
So it is not necessary. It is already stayed. list this matter after 6 weeks. This interlocutory application is in fact infructuous. Because you already have a stay granted by the trial court
That is the.
during the pendency of this appeal. List after 6 weeks.
Okay. May I please your lordship, my lords, we have received the LCR record,
Which item?
item 51, my lord. 7, item 7, my lord.
No. Iman Matisse. Your matter has not yet been called.
I apologize, your lordship. He said the-
Item number 6.
Item 6, standing.
So lordship, whatever be admitted and I'll deposit 50%. Provided lordship he files an.
Item 6.
Yes, my
There
lord.
is a delay.
No, my lord. Delay condone, my lord. Now it's for admission, my lord.
Delay condone.
Delay condone, my lord.
Where? In which IA?
Your IA is, my lord, the 24.
On 24,
30.
lordship.
Okay.
Substantial questions of law on page 8.
You have anything to say?
My lord, the deposit, my lord, 50% and we may be allowed to withdraw, my lord.
No, regarding admission of the appeal.
Well, regarding admission of appeal, my lord, I have come across on, my lord, the provision of section 30, my lord. That says, my lord, for filing this MFA, my lord, the appellant, my lord, they are required to deposit the entire amount before the commissioner. And thereafter a certificate need to be obtained. And that need to be accompanied with the criminal MFA.
Where is the provision?
Well, section 30 says, my lord.
Employees Compensation Act.
Yes.
May I say something? It is there, but
Employees Compensation Act.
as per decision of the Honorable High Court, lordship, and approved by, ratified by Supreme Court, last 20 years, almost, appeals, MFA appeals are filed without deposit. And
Where is that decision?
right, but I'll review it. But this is the way, lordship. Earlier, even I used to deposit. We all used to deposit before the commissioner. After that judgment, lordship, it has a.
Well, on this issue, my lord, I have come across several judgments of different high courts. Different high court says, my lord, on different contexts, my lord.
What our High Court say?
Our high court says, my lord, that judgment I don't have, my lord, but that says, my lord, only in certain facts and circumstances,
What?
not as a whole.
Certain facts and circumstances, what the deposit
Well,
need?
but in that case, my lord, the facts were not properly discussed even.
Like that. In fact, it has become almost standard practice, lordship.
No, there cannot be any standard
No, as
practice.
per the High Court judgment.
Yes,
As
there
per
may be.
judgment supported by the Supreme Court.
Where is that?
Lordship, because I did not think it would be raised this time. It has been going on for last
Well, if
20
he,
years.
my lord, because it's my lord, 50% and-
I'll bring it the next time.
Then we'll take it up day after tomorrow you bring, or in the next week. I am not admitting this appeal. Okay.
19th, because.
You also come prepared.
19th of,
Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. M. Datta, learned counsel for the respondent. This appeal under Section 30 of the Employees Compensation Act 1923 has been preferred by the appellant, namely SBI General Insurance Company Limited, impugning the judgment and order dated 24/3/2025 passed by the Commissioner, Employees Compensation Golaghat in EC case number 5/2024. Learned counsel for the respondent has submitted that as per section As per third proviso to section 30 of the Employees Compensation Act, no appeal shall lie unless the memorandum of appeal is accompanied by a certificate by a commissioner to the effect that the appellant has deposited the amount payable under the order appeal against. On this, Mr. R. Goswami submits that there is a judgment of this court which requires, which says that such deposit need not to be made while filing the appeal. He also submits that the judgment of the High Court has also been affirmed by another judgment of the Apex Court. He seeks some time to place the judgment before this court. Said judgment before this court. The prayer is allowed. Let this matter be listed again on 19th of May.
Order cycle 7.
My lords, the LCR report has been received, my lords. If your lordship may kindly list the matter for hearing.
Only service of notice among the response number 2 is not complete.
For the previous order. My lords, it has been completed, it has been fulfilled, my lords.
Not sure, my lord.
No, but last date you were directed to take steps. Again, respondent number 2. But no risk. You have not gone through the records.
My lord, if your lordship may kindly pass over, I'll check whether the service.
No, I have checked. It hasn't.
My lords, I'll cure that defect. My lords, I'll do proper service.
Heard Mr. D. Rathi, learned counsel for the appellant. Also heard Mr. B. Sharma, learned standing counsel NF Railway, appearing for respondent number 1. On perusal of the office note dated 6/5/2026, it appears that the service report in respect of notice issued to respondent number 2 has not yet been received. What will you do? You take fresh steps.
I'll take fresh steps.
The appellant is directed to take fresh steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable on
June.
3rd June.
Grateful. Much of.
Item number 8.
May it please your lordship. Lordship, the service is complete. TCI is also received.
My lord, kindly peruse office note dated 7/5/2026, my lord. They have to file amended cost title.
You have not filed amended cost item.
Your lordship, last time it was directed that the registry might do the necessary correction.
No, you have not gone through the order sheet. Order sheets clearly says that you have to file amended cost item.
There's been one confusion. So last order said that the registry should do the correction, but in the order sheet it was written that we do the correction.
Which order says registry shall do the correction?
Last time I appeared, the court directed the registry, your lordship.
No, have you gone through the orders?
The order said otherwise, your lordship.
You have to do otherwise. What order says?
Okay, lordship.
Heard Mr. What is your name?
J. Hawk.
Heard Mr. J. Hawk, learned counsel for the appellant. Also heard Ms. L. Sharma, learned counsel for respondent number
One my lord, insurance company.
one insurance company. Though it appears that the records of concerned MSC case have been received and the appearance of parties are also complete. However, the appellant has not yet complied with the order dated 13/3/2026 as no amended cause title of the memo of appeal has been filed in terms of the said order. The appellant is directed to file the amended cause title of the memo of appeal in terms of order dated 13/3/2026 within 2 weeks from the date of this order, list accordingly.
Item 9.
May I please, your lordships. This case for my lord, the IF for my lord, condemnation of delay, my lord, 313 days, my lord. And
Or
statement that
your claim case was dismissed or it is for enhancement?
dismissed, my lord,
Dismissed.
dismissed.
Yes, Miss Sakya.
I have stated my grounds for 5 and 6, my lord. in my
You are
grounds.
opposing?
Okay, we have to take instruction regarding this, whether we'll file any objection. Because the delay is 300 days.
Yes, 300 and
Heard Mr. S. Ahmed, learned counsel for the applicant. Also heard Ms. M. Sakya, learned counsel for
Respondent number 1.
respondent number 1 insurance company. Who submits that some time may be granted for taking instructions as to whether the respondent number 1 would be filing a written objection or not. The prayer is allowed. If the respondent number 1 intends to file any written objection, same shall be done before the next date fixed. Stop. On perusal of the order dated 6/5/2026 passed by the Lajima Court, it appears that notice issued to respondent number 2 is duly served. Stop. Let this matter be listed after 2 weeks on a date at the 22nd.
22nd.
23rd, Lordship, 22nd.
On 23rd of May.
Obliged.
23rd is Saturday. 25th of May, Lordship.
25th of May.
Obliged.
Obliged, Lordship.
Item number 10.
May I present your lordship? As per office note dated 1/4/26, lordship, respondent 6 file wakalatnama. As per office note dated 1/4/26, respondent 6 file wakalatnama for 4 and 5, lordship, insufficient address. Lordship, that is the address which was in the claim petition. So we may be allowed to take steps by publishing in the newspaper, lordship. Otherwise, they won't appear.
Heard Miss R.D. Mujumdar, learned counsel for the appellant. Also heard Mr. A.R. Agarwala, appearing for respondent number
1, 2, 3.
1, 2, and 3.
File wakalat.
On perusal of office note dated 1/4/2026, it appears that notice issued to respondent number 4 and 5 have returned with postal endorsement within inverted comma insufficient address returned to sender inverted comma close. Learned counsel for the appellant has submitted that notices were sent to the respondent number 4 and 5 in the same address as were mentioned in the claim petition before the claims tribunal. Therefore, she submits that the appellant may be allowed to take steps for issuance of notice upon respondent number 4 and 5 by substituted mode of publishing the notice in newspapers. The prayer is allowed. The appellant shall take steps for issuance of notice upon respondent number 4 and 5 by publishing the same in two newspapers. In one newspaper, which is circulated
In Kachar, Assam,
in the
district Kachar.
in the area where the last known address of the respondent number 4 and 5 is shown. The date of notice to be mentioned in the
In July, maybe Lord
date
Chief.
of appearance to be mentioned in the notice shall be 20 July.
20.
20 July. List this matter accordingly on 20th of July.
Lordship, IS, IS.
You are for reflect the name of Mr. S. Pegu. Ayaragalana for 1 to 3. Mr. S. Pegu for respondent number 6.
Lordship, IS civil is also there, 281524.
Lordship, in that we had already submitted in the last date that they have not made the owner driver party. So Lordship, and moreover, the order was,
Let me kindly be seen, Lordship.
Aye.
2815.
and the stay was full stay given by another bench. So it has to be listed before that same bench.
Lordship, we are that money decree is stayed, Lordship, without any deposit. So that may kindly be vacated and 50% at least may kindly be allowed to be deposit. Because this is taking time, Lordship.
No, Lordship,
Because
judgment is for pay and recovery. In absence of owner driver, how can that be? They have not made the owner driver party.
Lordship,
In the interlocutory application,
Yes, they have not made.
you may make them party.
last time we instance only 15 days time, Lordship.
Where?
Hearing in this last quarter in this regarding my kindly be seen, Lordship.
In IA,
Yes.
there is
Order dated
no. Order dated 2/5/2025.
2/5/2025.
No such indication.
Listed after four.
There is no indication.
Yes, Lordship.
No. Whether the tribunal directed you to recover same from the. Okay, then you have to make owner.
No, Lordship, in the board bill, Lordship, was the owner and driver did not appear, Lordship. And since the insurance company is present, the main indemnifier of the MR,
We indemnify the owner driver, Lordship. They are not present. In other case also, Lordship directed. I think Mr. Agarwal was in that case also, that he should make them party.
Well, this order is there, Lordship. When the Supreme Court says that when the money decree is there, there should be some deposit, Lordship.
No, that's right. You filed written objection. Hard.
Which objection will be on that point only, what will be the use? In the meantime, he can incorporate those owner and.
No, his submission is that the suit proceeded against them ex parte before
He did not file any appeal against the pay and recovery, Lordship. Even the claimant has not filed any appeal against the pay and recovery order. So in that view of the matter, if there is pay and recovery, the You can submit, otherwise don't disturb. When there is pay and recovery lordship, naturally the owner and driver are, the liability of owner comes from the driver, because actually what the driver has made the mistake. So vicarious liability is of the owner, and we as insurer are liable, the insurance company is liable because to indemnify the owner. In absence of the person who is basically liable and in absence of the person who is indemnified, how the insurance company can be directed to deposit any amount? And moreover, this order was passed by another bench, lordship. It has to be listed before that appropriate bench.
No, this is not a review of that order.
That is, lordship, basically it is a review only if they are asking to, what is their prayer, lordship, I'll
It is not a review.
just looking at. Modify the said order and be pleased to issue directions to, that is their prayer, lordship, to modify the order.
Lordship, this is not the final order, Lordship. This is interim order, Lordship. So step, this is the interim order. So this can be passed for the same civil bench, Lordship. And Lordship, this order was taken in our actions, Lordship. And they are judgment data.
I can file the objection, lordship.
They are judgment data, Lordship.
No, if both of you are praying for listing it before the same bench, let it be. The Ramesh, ifale sabo.
I 22068 petition.
Heard. Heard Mr. A.R. Agarwal, learned counsel for the applicant slash claimant, who submits that this interlocutory application has been filed by the applicant slash respondent claimants, praying for modification of the order dated 29/7/2024, passed by a coordinate bench of this court, whereby the execution of the impugned judgment was stayed till the pendency of this connected MSC appeal number 360/2024. He submits that since the claimant is the beneficiary of the compensation awarded by the impugned order, the amount deposited by the beneficiary of the impugned order, and since it is akin to a money decree, the stay ought not to have been granted without deposit of some portion of the awarded amount as a security by the insurance company. He further submits that since the order dated 29/7/2024 was passed by a coordinate bench of this court, within bracket, Honorable Mr. Justice P.J. Swikia, bracket close, and since a modification is sought for in the aforesaid order, this interlocutory application may be listed before the same bench. The learned counsel for the insurance company also submits that since a modification has been sought for in the order dated 29/7/2024, it is akin to reviewing the said order and it is appropriate, it would be appropriate if the matter is dealt with by the same bench. Considering the submissions made by learned counsel for both the sides, let this matter be listed before the appropriate bench, within bracket, Honorable Mr. No, Neligo, appropriate bench by the registry.
Date
On
21
what was the date in the
27/2026.
Honorable Justice is there, Lordship.
on the next date fixed, that is
20
21.
July 2026.
20 July 2026.
Lordship, that will be coming the final paper publication sector, Lordship.
Oh,
So-
তেতিয়া আপোনাৰ হৈও যাব নহয়?
It will help you.
Alia Blind.
I'm taking a short.
Take steps to Dusty because we have taken steps twice, but the same report has been there.
Heard Miss M. Sakya, learned counsel for the applicants. On perusal of the office note dated 28/4/2026, it appears that the service report in respect of the notices issued to respondents have not yet returned. Stop. Learned counsel for the applicant prays for allowing the applicant to take steps for issuance of notice upon the respondents by dusty mode. The prayer is allowed. The applicant shall take steps accordingly within 15 days. Returnable on 17th of July. In the event the notices are served through dusty mode, the applicant shall submit an affidavit in compliance thereto on the next date fixed, list accordingly.
Item number 12.
May I please, Your Lordship, in this, as per office note dated, since the respondent number 1 is yet to appear. From 2 to 7 and 8. 8 have already appeared.
So who is respondent number 1?
We are taking steps by speed post.
Who is respondent number 1?
So 1 is the wife of the deceased.
Wife of the deceased. And who are other respondents?
The wife, mother, father, sister of the deceased.
You take fresh steps.
See, the track records may be called for. We have taken steps like speed post.
When? When you have taken steps? In the year 2024. We will not get the track consignment report now. You take fresh steps. Heard, Miss, what is your name? P.
Fukan.
P. Fukan, learned counsel for the applicant. Also heard Mr. R.A. Chaudhary. R.A. Majumdar? R.A. Majumdar, learned counsel for respondent number 2 to 8. On perusal of the office note, it appears that the notices issued to respondent number 1 have not been served. The applicant is directed to take fresh steps for issuance of notice upon respondent number 1 by speed post along as well as by usual mode within 7 days from the date of this order, returnable on 26th June, list accordingly.
Apply. Item number 13.
But I for confirmation of delay, 26 days delay.
No objection, Lordship.
Heard Mr. M. Khan, learned counsel for the applicant. Also heard Ms. M. Sakya, learned counsel for respondent insurance company. This application under Section 5 of the Limitation Act has been filed by the applicants praying for condonation of delay of 26 days in filing the connected MAC appeal. The reasons for delay have been mentioned in paragraph number 4 and 5 of the instant interlocutory applications. Considering the grounds shown by the applicant, the learned counsel for the insurance company have raised no objection against the prayer for condonation of delay. Stop. I have gone through the grounds stated in the instant interlocutory application. Same appears to be sufficient cause which prevented the applicants from approaching this court by filing the connected appeal within the prescribed period of limitation, hence the delay of 26 days in filing the connected appeal is hereby condoned, and this interlocutory application is accordingly allowed. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
In the appeal,
Our names may be reflected. in-
Name of Ms. M. Swekya may be reflected in the cause list as engaged counsel for respondent number 1 insurance company henceforth.
Item 14.
cross objection. Is a cross appeal. Let notice me go it is at the system.
What has happened in the MAC appeal?
They made it-
Lordship, that Lordship office note dated 5/12/25. Respondent 1 Wakalatnama 2 and 4 AD card duly served, flag X, and for 3 Lordship not yet received back. We have to await.
Who is 3?
Driver. And LCR received.
Common order लिखे MAC appeal दो. Common order in cross objection in MAC appeal. Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. M. Khan, learned counsel for respondent number. In appeal, you are respondent number?
1.
Respondent number 1 / cross objector. On perusal of the
Because before that, before last order Lordship, that was the office note and they have not changed any office note after that about respondent number 3. The office note is 5/12/25. The case was last listed on 5/2/26.
it appears from office note dated 5/12/2025 that notice is issued to respondent number 2 and 4 have returned after due service. AD card issued to this, AD card issued along with the notices issued to, AD card sent along with the notices issued to respondent number 2 and 4 have returned with the signatures of the addressees. Hence, the notices issued to respondent number 2 and 4 are held to be duly served. It also appears that notices issued to respondent number 3 have not yet returned. You have to take fresh steps.
Lordship, right, here, Lordship, it can be waived, Lordship. Otherwise, he can take step in that, maybe he will come in his cross objection.
What is
There's no step.
cross objection is for enhancement.
Yes.
Yours is for
pay and recovery.
enhancement driver may not be necessary.
For pay and recovery also, because it is the owner we want to get it paid from.
Notice may be waived.
Waived. And
Learned-
since LCR received, Lordship, it has
Learned
no.
counsel for both the parties have submitted that since the notice issued to owner has been duly served,
And
the
it can be deemed served, Lordship, for
no only what basis we will.
because AD cut, CPC, Lordship, 30 days.
AD has not returned.
CPC doesn't say about AD, Lordship, that 30 days time in the correct address is taken.
Correct address.
And this was the address which was in the claim petition. So it can be deemed served, Lordship.
Which is the provision?
If I do not have the CPC right now. Order 5, Rule 20. Lordship.
No, at least we can go for
Waiving.
taking fresh steps.
Lordship, then waive, Lordship. We'll take that.
Or you show the provision.
Waive, Lordship. Then. Because HCR has come, we will be asking for recovery from the owner only. Owner has not appeared.
Served, and since the presence of the owner would be, the service of notice of the owner would be required for deciding both the appeals and cross objections. The notice to the driver of the offending, whether in the trial court they appear.
I'll just check, Lordship. Still I'll check. No, yes, they appear. 2 and 3.
The notice to the driver may be waived. The prayer is allowed. Let this matter be listed for hearing on August of date at the 10th of August, 28th August.
Highly obliged.
Item 19.
Lordship, 20 days delay in filing appeal. My friend has appeared for respondent number 1 to 3. And as per information received, Lordship, respondent number 4 has expired. And respondent number 5 notice has not returned. So notice was sent by registered post to AD. And appeal is basically on quantum. So I think my friend has no objection to the effect regarding condonation of delay of 20 days.
Yes, Lordship.
Notice
Lordship, I have no objection.
Appearing for 1
1
to
to
3
3.
is a claimant. And appeal is basically on quantum.
Okay. Heard Mr. S.K. Goswami, learned counsel for the applicant. Also heard Mr. I.M. Khan, appearing for respondent number 1, 2, and 3 / claimants. This interlocutory application has been filed by the applicant insurance company, praying for condonation of 20 days in filing the connected MAC appeal. Stop. Learned counsel for the respondents number 1, 2, and 3 / claimants submits that he does not have any objection if the prayer for condonation of delay is allowed. It also appears from the office note that who is respondent number 4?
4 is the owner.
The respondent number 4 has expired, and the notice issued to respondent number 5 has not yet returned. Learned counsel for the applicant submits that since the claimant does not have any objection against the prayer for condonation, and since the connected appeal is basically against the quantum of the compensation granted to the claimants, hence notice to other respondents may be waived. The prayer is allowed. I have gone through the grounds of delay stated in the instant interlocutory application. Considering the grounds stated therein to be sufficient cause which prevented the appellant from preferring the connected appeal within the prescribed period of limitation, the period of 20 days in preferring the connected appeal is no, not the period, the delay of 20 days in preferring the connected appeal is hereby condoned, and this interlocutory application is allowed. Let the connected MAC appeal be registered by the registry and list the same for admission
15 June.
on 15th of June.
Obliged.
Name of Mr. M. Khan may be reflected in the cause list henceforth as engaged counsel for respondent number 1, 2, and 3.
Obliged.
Item 20.
Yes, what is this?
Lordship, this regular first appeal has been prepared against the judgment and decree dated 29/6/2024.
Delay is there.
No delay, Lordship. On the last occasion, it was listed, but I overlooked the cost list. So I could not attend.
No, but this is a delay condonation application.
Yes, Lordship, I'm sorry, Lordship. There is a delay of 164 days. There is a delay of 164 days in
Heard, Mr. What is your name?
Novajit Bharani.
N. Bharali, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been preferred by the applicant / appellant for condoning the delay of 159 days in preferring the connected appeal, wherein the judgment and decree dated 29/6/2024 passed by London Civil Judge Senior Division, Kamrup, in title suit number 63/2023 has been impugned. Issue notice to the sole respondent. Issue notice to the sole respondent. The applicant shall take steps for issuance of notice upon the sole respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 19th of June.
Item 21.
Yes, Mr. Das.
Many people, Lordship. Lordship, as per the last order, madam, the track report is on record, madam. And madam, the notice was delivered on 8/4 April, madam. So that is the track, madam.
Heard, Mr. S.P. Das, learned counsel for the appellants. How many respondents are there? On perusal of the office note dated 7/5/2026, it appears that from the postal track consignment report of the notices sent to the respondent that the notices were delivered to the addressee on 8/4/2026. In view of the aforesaid fact, the notice issued to sole respondent is held to be duly served. The trial court records have been received from the trial court. Let this matter be listed for hearing on 6th of June.
Item 22.
My lord, service may be awaited in all the respondent, my lord. See,
6th, 9th of June. No, just a minute. One case of 9th of June.
my lord, service may be awaited in all the respondent, my lord. We have taken both issue notice from both.
Ms. L. Sharma, learned counsel for the appellant. Learned counsel for the applicant. No service report has been received in respect of notices issued to the respondent. The registry is directed to place the postal track consignment report of the notices issued to the respondents. Let this matter be listed again on
Publishing.
5th of June.
Item 23.
In this case, also, I beg your pardon. One thing is, also, the lordship is directed to take steps by usual process as well as by speed post. My junior has taken steps by usual process, and notice on respondent number 1 has been served, and respondent number 2 has not returned. There is no office note, and 58 days delay in filing appeal, and appeal is basically on quantum. The lordship claimant name has been shown in the cause list, and they have today.
No, today nobody has appeared. So in the meanwhile, you take steps. Heard Mr. S.K. Goswami, learned counsel for the applicant.
On respondent 2, lordship.
It appears that the respondent number 1 has filed wakalatnama in this case. However, the notice issued to respondent number 2 by usual mode has not yet returned. Stop. The appellant is directed to take fresh steps for issuance of notice upon respondent number 2 by speed post within 7 days from the date of this order, returnable on 26th of June.
Item number 25.
My pleasure. Lordship, may kindly see the office note dated 11/3. There is a confusion in the office note, in fact.
11/3.
Yes, 11/3/26.
17/3.
Yes, maybe 17/3.
What confusion?
Though it has been said to have been served, my lord, but all the envelopes and all has returned back, my lord, saying that addressee has left. In the later part, my lord, last part of the like flag pages, my lord, lordship will get it in flag pages. So remark is addressee has left. But the green flag shows, my lord, it is delivered.
Yes.
So there is a confusion, my lord. Anyways, my lord, lordship may allow me to take fresh steps by registered post as well as by dusty, my lord.
Heard Mr. A.N. Sharma, sorry, Mr. M. Fukan, learned counsel for the applicant, peruse the office note dated 17/3/2026, which shows that postal track consignment report indicates that the notice have been delivered to the addressee. However, however, it also indicates that the unserved notice have returned back with a postal remark within bracket addressee left, return to sender. Stop. Learned counsel for the applicant has prayed for allowing the applicant to take fresh steps for issuance of notice by speed post as well as additionally by dusty mode. The prayer is allowed. the applicant shall take steps for issuance of notice by speed post within 7 days from the date of this order, returnable on
26 June.
26 June. The applicant is also allowed to take steps for issuance of notice additionally by dusty mode. Stop. In the event the applicant is able to serve the notice by dusty mode, an affidavit in compliance thereto shall be filed by the applicant on the next date fixed. Listed.
Much of. Item 26.
None has appeared for the applicant on call. List this matter after 2 weeks on a date to be fixed by registry.
Item 27.
May it please your lordship, I appear for the opposite party numbers 1 and 3. In fact, the Wakalatnama also will be filed shortly.
I appear for a small four.
Lordship, regarding respondent number 3, Lordship, one Savita Boro has received the notice, Lordship. In that way, Lordship, service is complete, Lordship. There is a delay of 12 days, Lordship.
Ms. M. Chaudhary, learned counsel for the applicant. Also heard Mr. What is your name?
A.K. Chaudhary.
A.K. Chaudhary, appearing for respondent number 1 and 2, as well as Mr. R. Chakravarti, appearing for respondent number 4. Stop. On perusal of the office note dated 6/5/2026, it appears that the notice, the ID card he sent along with the notice issued to respondent number 3 has returned with the signature of one Sabita Boro thereon. Stop. The notice issued to respondent number 3 is also held to be duly served.
So far as my instruction is concerned, that respondent number 3 has already passed away. That is the instruction that I have from 1 and 2.
Who is 3?
3 is Lordship driver.
Who is Sabita Boro? Her relationship is
3 is the driver, Munindra Boro. He is expired, Lordship.
But then that is not a confirmed news, so let a report be furnished. Sorry, your lordship, this Purno Das, you are referring for Purno Das, no?
No one is expired.
Okay.
No one is.
who has expired.
Munindra Boro to number 3, except police.
Then it is okay, if they have accepted it.
No, whether you are opposing the prayer for condonation.
There is a delay of 12 days. We are not opposing it, Your Honor.
Yes, Mr. Chakravarti. Stop. This application under Section 5 of the Limitation Act has been preferred by the applicant United India Insurance Company Limited for condonation of delay of 12 days in preferring the connected bank appeal, wherein the applicant has impugned the judgment dated 6/11/2025 passed by the Motor Accident Claims Tribunal, Bongaigaon, in MEC case number 320/2019. The cause of delay has been stated by the applicant in paragraph number 3.
Four.
Therefore, paragraph number 4 and 5. 4 of the instant interlocutory application. The learned counsel for the respondent number 1, 2, and 3. 1, 2, and 5. 4 have not objected to the prayer for condonation of delay. Stop. After going through the grounds stated in paragraph number 4 of the instant interlocutory application, this court is of the opinion that said ground may be regarded as sufficient cause which prevented the applicant in preferring the connected MAC appeal within prescribed period of limitation. Accordingly, the delay of 12 days in preferring the connected appeal is hereby condoned when this interlocutory application is disposed of. The registry is directed to register the connected MAC appeal and list the same for admission after a week on a date to be fixed by it.
Showing the name of the counsel appearing for 1, 2, and 4.
Name of that counsel for respondent number 1, 2 and 1 and 2, as well as learned counsel for respondent number 4 may be reflected in the cause list henceforth.
After admission.
After admission.
So Lordship may fix a date for it.
No, in the next week. Okay. Instead of next week, let this matter be listed on 26th May.
Must oblige.
Item 28.
May I please your Lordship? Lordship, as per office note order dated 6/5/26, respondent number 1 and 3 is served. The respective respondent number 2 has not arrived. Answered both. Respective respondent number 2 is answered.
Take fresh steps. Heard Mr. S. Fegu, learned counsel for the applicant. On perusal of the office note dated 6/5/2026, it appears that notice issued to respondent number 1 and 3 have been duly served, whereas the notice issued to respondent number 2 has not yet returned. The applicant shall take fresh steps for issuance of notice upon respondent number 2 by speed post as well as by the usual mode within 7 days from the date of this order, returnable on 26 June.
Item 29.
Sorry, we have taken steps only on 8/5/2026, Lordship. So we have.
Ms. R.D. Majumdar, learned counsel for the
Applicant.
The notice is issued to the how many respondents are there? Respondents have not yet returned. The registry is directed to place the postal track consignment report of notices issued to the respondent by speed post before this court on the next date fixed. The list this matter again on 26th May.
26 June.
26 June.
Lordship, same is the case with item 33, 34, but I can wait, Lordship. Same thing.
Item 33,
And 34, same type of order.
34, same order.
Alia, please.
Item 30.
Yes.
Please, Your Lordship. Lordship, in this case, answer notice has been received in this paper press number 123. With the postal email that there is no such person, Lordship. So I have different address also, Lordship, which I mentioned in the cost table. So I will be allowed to take step, Lordship.
Take steps by? By which one?
Speed post, Lordship.
Fresh steps.
Different address.
Heard Mr. R. Sharma, learned counsel for the respondent, learned counsel for the applicant, on perusal of the office note dated 6/5/2026, it appears that the notices issued to respondent number 1, 2, and 3 have returned within postal endorsement within inverted comma. No such person in the address. Stop, return to sender, inverted comma close. Whereas notice issued to respondent number 6 and 7. What happened to 5?
Lordship, 4.5 and minus, Lordship.
Notice 6 and 7 have not yet returned. Learned counsel for the applicant submits that the applicant may be allowed to take fresh steps on respondent number 1, 2, and 3 at their alternative address. The prayer is allowed. The steps shall be taken for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on
19th June.
from 19th of June. Please.
Item 31.
My lord, service may be awaited, madam, in all the respondent, my lord.
Heard Ms. L. Sharma, learned counsel for the applicant. On perusal of the office note, it appears that the service report in respect of notices issued to respondents by speed post have not, is still awaited. The registry is directed to place the postal track consignment report of notices issued to all the respondents by speed post before this court on the next date fixed. List this matter again on 12th of June.
Item 32.
My lordship, the service may be awaited because no unsubmitted notice or service report has been received.
In respect of you, for whom you are
Lordship, I am appealing for respondent number 2, lordship. Today we have 5 vakalat.
heard Miss A. Biani, learned counsel for the respondent applicant. Also heard Miss, what is her name?
Ji Dekal.
G. Deka, appearing for respondent number 2, who submits that she would be filing her wakalatnama during the course of the day. On perusal of the office note dated 6/5/2026, it appears that notice issued to respondent number 1 has not yet returned. The registry is directed to place the postal track consignment report of notices issued to respondent number 1 by speed post before this court on the next date fix. Let this matter be listed 15th June.
Item 35.
Yes, my lord, I filed an IA on behalf of the claimant, my lord, the respondent, the appeal, my lord, for withdrawal of the 50% of the amount, the awarded amount.
ये हमें शायद दो
Certificate.
disposed of.
128.
Yes, what
Lordship, I have an objection, Lordship. Here, Lordship, we have filed the appeal, Lordship, mainly on the ground that it's a goods carrying vehicle, and he was traveling as an occupant of the Bolero pickup, Lordship. And secondly, Lordship, the vehicle has no valid permit and no valid DL, Lordship. These are the points, Lordship, whereby there is a violation of terms and conditions of the policy. Therefore, Lordship, at this stage, may not be entertained, Lordship, for the allowance of the 50%.
no, you're pleased that the
Yes.
owner would be liable.
Yes, Lordship. So far as service, Lordship, service is not complete so far as owner and driver is concerned, Lordship. ID card is not yet received.
2023 notice was issued, my lord. Even appellant has not, respondent has not received one. Recently, they came to know about last. It was issued my.
How much was the?
8 lakh.
Let them file the indemnity bond.
Where is it that the owner and owner may appear before this honorable court, Lordship, because we have taken steps and service report is awaited. Lordship, may kindly peruse the office note, Lordship. ID card is not yet received.
No, whether any notice was issued to owner while staying no notice was issued.
Notice was issued.
Not even to the claimant.
On appeal, Lordship.
In the stay application.
It has come, when it has come for the admission, Lordship, at that time the order was passed, Lordship. Staying the order, Lordship, in judgment. Office note, Lordship, 3426. In the appeal, Lordship.
When have you taken steps?
Taken steps.
Year 2023, ma'am.
You take fresh steps.
Lordship.
Let them take one. We'll consider your after service of
Lordship.
heard Miss M. Chaudhary, learned counsel for the appellant. Also heard Mr. J. Loskar, learned counsel for respondent number
1, 2.
Respondent number 1,
2 and 3.
1, 2, and 3. It appears from office note that notices issued to respondent number 4 and 5 have not yet been received back. However, it also appears that steps for issuance of notice upon said respondent was taken in the year 2023. Stop. Hence, the appellant is directed to take fresh steps for issuance of notice upon respondent number 4 and 5 by speed post within 7 days from the date of this order, returnable on 22nd June.
Copy of memo.
I furnish.
You furnish, let a copy of memo of appeal be furnished to the learned counsel for respondent number 1, 2, and 3.
Item number 36.
Lordship, my senior has already mentioned the matter. There is a delay of continuation of 73 days, Lordship.
Good. Mr. R. Dubey, learned counsel for the appellant. Delay interlocutory application. Learned counsel for the applicant. This interlocutory application under Section 5 of the Limitation Act has been preferred by the applicant praying for condonation of delay of 73 days in preferring the connected land acquisition appeal. Stop. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 19th of June.
37.
That is the lordship. I have filed IA for early hearing, lordship.
Heard Mr. R. Sharma.
Yes, Honorable.
A. Sharma, learned counsel for the applicant. In the appeal, the service is complete.
Yes, your lordship.
A. Sharma, learned counsel for the applicant. This also heard Mr. S. Datta, learned counsel for the insurance company.
Page 6, paragraph 4.
Mr. Sharma, you are appearing for whom?
I'm for number 1 and 2, lordship.
Stop. Last line case. This interlocutory application has been filed by the applicant / claimants praying for expeditious hearing of the connected appeal number, connected MAC appeal number 393/2022. The prayer is not opposed to by learned counsel for the insurance company. Hence, let this matter be listed. Early June or the 4th week.
10th of June.
4th week. 23rd June. Let this matter be listed again on 23rd of June.
Obliged.
38.
This interlocutory application is disposed of.
May I please, your lordship? This is a condonation of delay petition for 89 days.
But Mr. What is your name?
A. Agarwal.
A. Agarwal, learned counsel for the applicant. This interlocutory application has been filed by the applicant praying for condonation of delay of 89 days in preferring the connected MAC appeal. Let the notices be issued to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 19th of June.
Please.
Item 39.
May please, your lordship. There's a delay of 133 days.
Mr. S. Ahmed.
Islam.
Sorry, S. Islam, learned counsel for the applicant. This interlocutory application has been filed by the applicants praying for condonation of delay of 133 days in preferring the connected MAC appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by user mode within 7 days from the date of this order. Returnable on
19 June.
19th June.
Published.
40.
Item 40. My lord, this is a application for petition for a delay of 425.
How much delay?
425 days.
425 days. What is your name?
A. Goswami.
Heard Mr.
A. Goswami.
A. Goswami. Learned Council. Baki ke hobo. 425 days delay. Steps within 7 days. Returnable on 19 June.
The both the manner very fixed for hearing.
I'm appearing for the respondent now.
'51 and 52. What is the prayer?
This is the case of the.
My lord, matter may be fixed for hearing. Clear.
Case of the non-granting of the concession at the rate of 25%, but the railway granted 20%. The claim of the respondents.
Item number, both are separate appeals
Same
arising out of same matter.
matter. Again, the common judgment.
51 and 52. Heard Miss U. Chakravarti, Learned Counsel for the appellant.
Special senior election.
Learned Senior Railway Counsel appearing for the appellant. Also heard Mr. D. Rathi, Learned Counsel for the respondent. It is submitted at bar that these appeals are ready for hearing and a date may be given for hearing of the matter. Accordingly, let this matter be 11th of August.
Much obliged.
Obliged.
Judgment, item number 47.
For reasons mentioned in the judgment, this appeal is dismissed.
Item number 48.
For reasons mentioned in this judgment, this appeal is also dismissed. I have given certain clarification about Nanjappa. You go through tomorrow. Tomorrow it will be uploaded.
And the statutory deposit
It is taken care of.
amount already paid, deposited here.
Yes, everything is taken care of.
Item number 41.
May I please, your lordship?
Yes.
Lordship, there is a delay of 131 days for filing the MSc appeal, lordship.
Mr.
A.U. Ahmed.
A.U. Ahmed, Learned Counsel for the applicant. This interlocutory application has been filed by the applicant praying for coronation of delay of how many days? 131 days in filing the connected MAC appeal. Let the notice be issued to the respondents. How many respondents?
3 respondents.
Respondents. The applicant shall take steps for issuance of notice by speed post as well as by user mode within 7 days from the date of this order, returnable on 17th of June.
Item 42.
Please, your lordship. Your lordship, this IA is for delay 56 days.
What is your name?
R Das, on behalf of RK Bhadra.
Counsel R. Das appearing on behalf of. No, your name is there in the cause. R. Das appearing for the applicant. Delay is of 56 days. Take steps within 1 week. Returnable on 24th June.
Item 43.
Well, there is a delay of 108 days in preparing the agreement.
A. Bhattacharya. 108 days, 7 days steps, take steps. Returnable on 24th June.
Public. Item 44.
22 days delay.
R. Sharma, 22 days. Returnable on 24th June.
Item 45.
Wait, please. There is a delay of 139 days, my lord, out of which, my lord, 127 days, my lord, I filed, my lord, revision, civil revision, my lord. But later on, it was came to my notice.
You are appearing for?
Lordship, I'm for caveat, Lordship. Lordship, in this matter, we want to file an objection in.
Heard Mr. J.C. Gaur, learned counsel for the applicant. Also heard Miss, what is her name?
R. Jukli for the caveat.
R. Jugli, appearing for the caveators. Who is the caveator? All the respondents. Stop. This interlocutory application has been filed by the applicant praying for condonation of delay of 139 days in preferring the connected appeal. Stop. Learned counsel for the caveators/respondents submits that they may be allowed some time to file the written objection against the prayer made by the applicant. The prayer is allowed. How much time you want? Let this matter be listed last week of June.
19.
On 19th of June.
Item 53.
Wait, please, your lordship. Your lordship, the TCR has been received. Kindly fix the matter for hearing.
Ramesh, record code. Item 53. Call next item if you are not finding the record. We'll take it up after some.
Item 53. 53.
None appears for the appellant on call. What is your name?
A. Dev on behalf of D. Rathi.
Heard Mr. A. On behalf of?
D. Rathi.
Heard Mr. A. Dev appearing on behalf of D. Rathi. It is submitted by learned counsel for the respondents that this matter is ready for hearing. List this matter for hearing. Date Atadio, hearing.
6 August.
6th of August.
Item 54.
My lord, here, my lord, we have.
Hearing kiman rakise.
Here, my lord, we have filed affidavit today, my lord. For paper publication, my lord.
For issuance of notice on which respondent?
For my
4, 5, 6.
4, 5, and 5, 6, and 7. 5, 6, and 7, my lord.
The affidavit is not on record.
Today itself we have.
Heard Ms. N. Sharma, learned counsel for the appellant. Also heard Mr. S. Dusad, PD Bhuya, appearing for respondent number 1, 2, 3. Learned counsel for the appellant has submitted that the appellant has taken steps for issuance of notice upon remaining respondents by substituted mode of newspaper publishing the notice in newspapers as was directed by this court. She also submits that the appellant has filed the affidavit in compliance thereto today only. However, same is not brought on record. She requests for bringing the affidavit on record. The registry is directed to place the affidavit in compliance filed by the present appellant on record on the next date fixed. Let this matter be listed. June or first week. 8 June.
Item 55.
So your services complete, your lordship, the LCR has not yet been received, so your reminder may be sent.
And Mr. S.P. Sharma, learned counsel for the appellant. It appears that the records of MSC case number 1002/2022 has not yet been received. In spite of issuance of repeated reminders for the same. Let a report report be called for from the Motor Accident Claims Tribunal number 2, Kamrup Metro, Gauhati, as to why, in spite of repeated reminders, the records of MEC case number 1002/2022 has not yet been sent to this court. Let this case be listed for this report, furnishing report on 17 June.
Item 56.
Please, Your Lordship, in this case, Lordship, service complete and records also received, Lordship. So may I pray to fix a date for final hearing, though this is a 2025 matter, Lordship, by the judgment of the learned trial court. I was directed to pay the consideration money refund amount to the plaintiff, and accordingly we have deposited. Notice was also issued to the plaintiff to receive the amount. Whether they received or not, that is not within the knowledge. Appellant is the plaintiff.
This was a
Regular
specific performance of.
Yes.
The matter will be fixed for hearing, date may be fixed, so we have no objection.
Third, Mr. A.
Yes, Sikdar.
Third, Mr. A.R. Sikdar, learned counsel for the appellant. Also heard Ms. R. Chaudhary, learned senior counsel assisted by Ms. S.C. Murtaja, learned counsel for the respondent. It is submitted at bar that this matter is ready for hearing. Let this matter be listed for hearing on
August, 11 August.
11th of August.
If possible, on 16th of June, Lordship.
No, it may not be possible because we are full. 11th of August.
Item 57.
In this case only, reminder may be issued. PCR has not yet received.
Heard Miss R. Chaudhary, learned senior counsel, assisted by S.C. Murtaja, learned counsel for the appearance is complete. None has appeared for the respondents. On perusal of the office note dated 27/3/2026, it appears that the trial court records have not yet been received. In spite of issuance of reminder, let a fresh reminder be issued to the trial court.
6 appeared, Lordship.
For records. Let this matter be listed again on. Mhm. 23rd June. 23rd June. On last date, they appear. Today no one is appeared.
In the morning, they seen the office note and then requested me to fix a date for records.
Okay.
And 7 and 8 government, Lordship.
Okay.
Yes, for obliged.
Item 46.
Baki Kumai. What is your metal? 58 matane.
Item 58.
You record to do. Yes.
Due to some delay, we could not take steps earlier, Lordship, and we have taken steps today.
Heard Miss
H. Burra.
H. Barua, learned counsel for the appellant, who submits that due to some miscommunication, the appellant could not take step earlier for issuance of notice upon respondent. However, she submits that today the steps for issuance of notice upon respondent has been taken. Hence, she prays for awaiting the service report. The prayer is allowed. Let this case be listed again on 17th of June.
Bless.
Item 46.
What? Not legal opinion.
Interesting. Yes.
I'm for the respondent number 2 and 3. Okay. I'm paying a debt for also. And number of times I'm communicate with try to communicate to the respondent number 2 and 3. Also, unable to communicate.
Who?
Respondent number 2.
Who are 2 and 6?
2 and 3, owner and driver.
My appeal is against the owner only, Lordship.
Respondent number 2 is the owner.
According to you, you are not liable, he is liable.
Check this one. So he has to come and has to be there.
Why you are seeking date? You are unable to contact with the owner. Yes, Mr. Jha.
I have responded, I am the third party, sufferer.
Sufferer.
Or date may be given here, my letter.
Okay. Heard Mr. R. Goswami, learned counsel for the appellant. Also heard Mr. N. Jha, learned counsel for respondent number
1.
Respondent number 1, as well as Mr. What is your name? B. Sutia, appearing for respondent number 2 and 8, who submits that as he is unable to contact with respondent number to an end. Some time may be granted to him so that some instructions required before making his submission in this appeal may be taken from the said respondent. The prayer is not opposed to by the other councils, hence same is allowed. When
Solid may be given the person.
suggest
No, 5th of June to 5 years.
27, 28 of May.
27.
Otherwise, the end of June. Huh?
28 due. 24. 24 due.
No. Plus
okay, 28th May.
28.
Let this matter be listed again on 28th of May.
What's it? Finally, sent that.
When?
5th of June, what's it?
Okay, okay, 5th of June. Let him. Yes.
5th of either 5th of June or 5th of July. Lordship. I don't know the list for the other cases in today of June. May I can say 28. I can readily agree.
28, you're.
Or maybe the later part of June, Lordship, so that I can manage my dates.
No.
28, what's it? Mazin fix matter fix yes. 16 June.
Yes, so I'll be able to.
16 June almost.
Okay, 16 June. Let this matter be listed again on 16 June.
Hello.
Problem.
Item number 59 and 60.
May please your lordship. In this case, I'm appearing for respond number 2 of 59 or 63. Not 59 plus.
Sorry, sir. Can it be on some other day? Today I have some difficulty. I am for respond number 1.
Yes,
Yes, Mr. Das.
All.
Mr. Bhattacharya is seeking some.
Otherwise, my lord, better is very urgent. Client is insisting me, my lord. So, short date maybe.
Short date. Even within this week, I am ready to.
It was filed in the year 2020.
Yes, I understand.
He has not received due to the death of parents in accident, my lord.
Heard Mr. H. Das, learned counsel for the appellant. Also heard Miss M. Chaudhary appearing for respondent number 2, as well as Mr. A. Bhattacharya
Respond number 1.
appearing for respondent number 1. SP Sharma is also appearing.
60.
And Mr. SP Sharma appearing for respondent number 3 in MAC appeal number 107/2020. Learned Mr. A. Bhattacharya, learned counsel for respondent number 1, has submitted that he has some difficulty today and therefore prays for a short date. The prayer is not opposed to 6th of June. Let this matter be listed again. 6th of June. Yes, Mr. Gogoi.
Item number 16.
Both will come on the
Both will come together.
Item number 50.
Item number 57
My name.
reflect the name of Mr. T.R. Gogoi.
Respondent number 7 and 8
Respondent number 7 and 8.
of like.